Constitution. Background. Since the adoption of Indian Constitution, debates have started regarding the power of Parliament to amend key position of the Constitution. In early years of independence, Supreme Court considered that absolute power to Parliament in amending the Constitution, as seen in the verdicts like Shankari Prasad case in 1951 and Sajjan Singh case in 1965. In both the cases, court ruled that term law in Article 13 must be taken to mean rules or regulations made in the exercise of ordinary legislative power, not the amendments to the Constitution in exercise of constitutional power under Article 368. This meant Parliament had the power to amend any part of the Constitution, including fundamental rights. Article 13 reads, "The state shall not make any law which takes away or abridges the right conferred by this part 3, and any law made in contravention of this clause shall, to the extent of contravention, be void." However, in the Golaknath case 1967, the Supreme Court held the Parliament could not amend fundamental rights, and this power would be only with the Constituent Assembly. The court held that an amendment under Article 368 is a law within the meaning of Article 13 of the Constitution, and therefore, if an amendment takes away or abridges a fundamental right conferred by Part 3, it is void. To get over the judgment of Supreme Court in the Golaknath case 1967, R.C. Cooper case in 1970, Madhavrao Sindhia case 1970, and the then government headed by Prime Minister Indira Gandhi had enacted major amendments to the Constitution, that is 24th, 25th, 26th and 29th. All the four amendments brought by the government were challenged by Keshwananda Bharati case. In Keshwananda Bharati case, a relief was sought against the Kerala government. Two state land reform laws which impose restrictions on the management of religious property. Two state land reform laws which imposed restriction on the management of religious property. The case was challenged under Article 26 concerning the right to manage religiously owned property without government interference. Question underlying the case: was the power of Parliament to amend the Constitution unlimited? In other words, could Parliament alter, amend, abrogate any part of the Constitution, even to the extent of taking away all fundamental rights? The Constitutional Bench in Keshwananda Bharati case ruled by 7-6 verdict that Parliament could amend any part of the Constitution, so long as it did not alter or amend the basic structure or essential feature of the Constitution. However, the court did not define the term basic structure and only listed a few principles like federalism, secularism, democracy as being its part. The basic structure doctrine has since been interpreted to include the supremacy of the Constitution, rule of law, independence of judiciary, doctrine of separation of power, sovereign democratic republic, parliamentary system of government, principle of free and fair election, welfare state, etc. An example of application of basic structure is S.R. Bommai case in 1994. In this case, the Supreme Court upheld the dismissal of BJP governments by the President following the demolition of Babri Masjid, invoking a threat to secularism by these governments. Argument related to basic structure. Critics of doctrine have called it undemocratic, since unelected judges can strike down a constitutional amendments. At the same time, its proponents have held the concept as a safety valve against majoritarianism and authoritarianism. Origin: the basic structure theory was first introduced by Justice Mudholkar in Sajjan Singh case by referring to the 1963 decision of the Supreme Court of Pakistan. Chief Justice of Cornelius of Pakistan had held that the President of Pakistan could not alter the fundamental features of the constitution. Sikri, Justice Sikri explained that concept of basic structure included supremacy of the constitution, republican and democratic form of government, secular character of the constitution, separation of power between legislature and executive and judiciary, federal characteristics of the constitution. Two more judges, Shelat and Grover, added two more basic structure to the list. The mandate to build the welfare state contained in the directive principles of state policy, unity and integrity of nation. Justice Hegde and Mukherjee identified a separate and shorter list of basic structure, that is sovereignty of India, democratic characteristics, character of polity, unity of the country, essential feature of individual freedom and secured the citizens. Mandate to build a welfare state. Justice Jaganmohan Reddy stated that elements of basic feature were to be found in preamble of the constitution, provisions into which they translated as sovereign democratic republic, parliamentary democracy, three organs of the state. He said that the constitution would not be itself without the fundamental freedoms and directive principles. Only six judges on the bench, therefore minority view, agreed that fundamental rights of the citizens belong to the basic structure and parliament could not amend it. Minority view in the judgment. The minority view delivered Justice A. N. Ray, whose appointment to the position of Chief Justice over and above the heads of three senior judges soon after the pronunciation of Keshwananda verdict, was widely considered to be a politically motivated. Justice M. H. Beg, Justice K. K. Mathew, Justice S. N. Dwivedi also agreed that Golaknath had been decided wrongly. They upheld the validity of all three amendments challenged before the courts. Justice Ray held that all parts of the constitution were essential. No distinction could be made between the essential and non essential parts. All of them agreed that Parliament could make fundamental changes in the constitution by exercising its power under Article 368. In summary, the majority verdict in Keshwananda Bharati recognized the power of Parliament to amend any or all provisions of the Constitution provided such an act did not destroy its basic structure. But therefore, no unanimity of opinion about what appoints to that basic structure. Though the Supreme Court very nearly returned to the position of Shankari Prasad in 1952 by restoring the supremacy of Parliament's amending power. In effect, it strengthened the power of judicial review much more.